Okay, so think about this for a second, right? Like, how much of your day actually relies on these, like, simple agreements? I mean, the coffee you got this morning, or like your streaming subscription, even just like the vibe you have with a coworker about sharing work, like those unspoken things. These are all promises, right? It's contract law that gives us the rules of the game.
Yeah, totally. It's this like hidden framework that shapes so much, but we don't often think about it. So for this deep dive, let's get into some of the core parts of how it all works. We're going to look at these like essential elements and the different ways obligations and terms in contract law are classified using stuff from the University of Pretoria's Law of Contract module.
Okay, so this might sound like some super dry, like academic stuff, but trust me, it's not. Because once you get these core principles, it's like you have this, I don't know, superpower when you're dealing with any agreement. Like imagine knowing exactly what you're getting into, your rights, what you got to do. Pretty useful, right? So first things first, when we say legal obligation, what does that actually mean?
So a legal obligation, it's basically a bond, right? This like recognized legal bond.
Yeah.
It gives one party, the creditor, a right, and the other party, the debtor, a duty to do something specific or maybe not do something. What makes it really different is it's binding. It takes a promise and makes it legally enforceable. And the thing is, these obligations, they're not all the same. You can classify them in a bunch of ways, and those ways, they kind of overlap, you know?
Overlapping, got it. Okay, so to start figuring out these different types of obligations, the material talks about these civil, natural, and then moral obligations. What are the big differences there? What do we need to understand?
Okay, so let's start with the civil obligations. These are the ones we usually think about with contracts, right? Like legally binding stuff. The law is like, yeah, these are real and it'll enforce them. If someone doesn't follow a civil obligation, the creditor can go to court, you know? They can try to get something for that breach of contract. Remember that lease agreement. Your obligation to pay rent, that's civil. If you don't pay, well, your landlord has legal options. So that enforceability, that's the key thing.
Right. The law's got your back if civil obligation is broken. Now, moral obligations, those are more about, like, personal ethics, right?
Exactly. Just ethics, your own sense of right and wrong. No legal power whatsoever. So, like, say you feel like you should help your neighbor with something. Great. But they can't sue you if you don't. It's all about your own values. And those are different for everyone. What matters here is the law doesn't get involved in personal ethics.
Okay, so civil is the law, moral is personal. Now, natural obligations. Now, these are kind of interesting, right? Like, you feel you should do it, but it's not legally enforced. How does that even work?
They're in this weird in-between space. The debtor, they feel this pull to fulfill the obligation, like a debt of honor. But, and this is important, the courts won't force them. But here's the catch. If they do fulfill it, they can't be like, just kidding, give it back. The law recognizes what happened, even though it wouldn't have made them do it.
Okay, I need an example, because that's a bit tricky.
Let's say there's a debt, but too much time's passed legally to claim it. It's prescribed, no more civil obligation to pay, but the person might still be like, I gotta do this, so they pay. Later, they can't run to court and say, hey, that debt was dead, give me my money back. It doesn't work that way. So the law respects that honor thing, even if it can't force it.
That's a pretty cool distinction.
Yeah.
All right, moving on. Reciprocal obligations. Just the name, it sounds like some back and forth, right?
You got it. It's where two, maybe more, parties have obligations so tied together, each one's performance is why the other's doing theirs. Like this core idea of you scratch my back, I scratch yours. It's all about that mutuality. Think of it as if you do this, then I'll do that.
So it's linked. Everyone has to do their part.
Yeah. Three things are big here. Mutuality, interdependence, enforceability. Mutuality means both sides have obligations to each other. Interdependence means one side's action is dependent on the others. And enforceability, well, if one side does their thing, they can use the law to make the other side do theirs. Classic example. The sales contract. Seller has to give you the goods, but only because you're paying. You got to pay, but only because they're giving you the stuff. If one messes up, the other one doesn't have to hold up their end, and they can go to court.
So it's not just I do this, you do that, but like my action relies on your action, and we can hold each other to it. Okay, next up, we've got a whole bunch. Simple, alternative, generic, and facultative obligations. That's a lot. Let's start with simple, which sounds, well, simple.
It is. Simple obligation, pretty self-explanatory. One side has to do one specific thing for the other, no options, no changes. Like selling a car for a set price, boom, done. Clear, direct, one duty.
Gotcha. Alternative obligations, though, that sounds more complex. Like you have a choice.
Yep. Exactly. Here, the debtor, they get to pick between a few different actions to fulfill their obligation. Unless the contract says otherwise, it's usually their pick. But, and this is key, the options have to be spelled out clearly in that contract. If not, the whole thing can be too vague, and then it might not be valid.
So it can't be like, you owe me
Oh, it's
something.
gotta be concrete, like pay me 1,000 rand or give me that antique lamp. Once the debtor picks, it becomes a simple obligation. They're stuck with that choice, legally.
Pick a path, got to stick to it. Generic obligations, is that like buying, I don't know, a non-specific thing from a category?
Basically, yeah. Here, you're not talking about one specific unique item. It's defined by its kind, like its category. Imagine agreeing to buy, say, a ton of wheat or 10 liters of olive oil. You're not talking about which bag of wheat or bottle of oil. It's the type that matters.
And who gets to pick the exact stuff within that category?
Usually the debtor, unless the contract says otherwise. But two things matter. The amount has to be clear, no vagueness, and while the exact item isn't set in stone, it's got to match what you agreed on. If you order a dozen apples, you can't be given 12 rotten ones, right? They got to be, proper apples.
Makes sense.
Yeah.
A category, set amount, and the quality has to be right. Last one, facultative obligations. Does this mean like optional?
Kinda. The debtor has this flexibility. Here, they mainly have to do one very specific thing. But they get this option. They can swap it for something else if they want. So there's the main duty, but with this escape route built in just for them.
Like, delivered this book, but I can give you this other one of the same value if I choose.
Exactly. Main duty is that specific book. But they can use their faculty, their option, to give the substitute instead. If they don't swap, they got to do the original thing. So you got to understand, there's that main duty with this alternative they might use.
All right, I'm getting a much better idea of all these obligations and how they work in real life. Now, the study guide goes on to divisible and indivisible performance in contracts. This feels like another big distinction, right? Break it down for us.
It's huge, yeah. Affects how obligations are done and enforced. The main point is, both the doing of the thing, the performance, and the whole contract can be divisible or indivisible.
Performance first. What makes something divisible?
Divisible performance is when you can break it down into parts, separate, independent parts, and each part can be done on its own without messing up the whole thing. Like building 10 houses, all the same, you build one, deliver it, that's separate from the others. The obligation to build 10 is divisible into 10 little obligations. And importantly, payment can often be linked to those parts as they're done.
So invisible is you got to do the whole thing for it to matter.
Exactly. It can't be broken down into meaningful chunks. Got to be complete. Think of it like playing a concerto on piano. Playing part of it doesn't count, does it? You got to play the whole thing for it to be the performance you're supposed to give.
Okay, that makes sense when it's about the action itself. What about the contract overall? Can a whole contract be divisible?
Totally, yeah. It's like a bunch of mini contracts all in one package, each with its own obligations. If it's divisible, it's almost like you made several separate agreements all at once.
So if one part goes wrong, the rest can still go ahead.
That's one big implication. Here are a few more. Each part has to be a valid contract on its own. If there's a breach in one part, it's dealt with separately from other parts. Payment can be tied to each part's completion, and if only part of it isn't done, damages are calculated based on that specific part, not the whole thing.
And what about indivisible contracts? What does that mean for you practically?
Well, it's treated as one big solid agreement, so it's got to meet all the requirements for a valid contract altogether. Even a tiny bit of non-performance can be a breach of the whole thing. You usually only get full payment once the entire performance is done. And if there's a breach, damages are based on the value of the whole thing, since doing only part of it is often like doing nothing at all, legally, in these cases.
Yeah. Gotcha. Whether a performance and the contract itself are divisible or not, that's super important to know when you're making agreements. Now we're shifting gears a bit to the actual stuff in those agreements. Contractual terms. The material lays out three main categories: essentialia, naturalia, incidentalia. What do these fancy words mean for someone looking at a contract?
Think of them as tools to help you analyze what's in a contract. They can overlap, but they're a good way to see where the content comes from. Remember, a lot is what you negotiate, but some comes from the law itself.
Essentialia first.
Mm-hmm.
Sounds like, well, the essential parts.
You got it. These are the must-haves, the core bits that make it that specific type of contract. They're what makes a sales contract different from a lease contract, for example. So if
Yeah.
you're looking at a sale, the essentialia would usually be the parties involved, the buyer and seller, the price, and what exactly is being sold. Without those, it's not a legally valid sale contract. These are like the foundation defining what kind of deal you're making.
So the non-negotiables, they make it that type of contract. What about naturalia? Should I think of that as like things that are automatically included?
That's a good way to put it, yeah. These are terms that aren't written in the contract, but they're there anyway because the law says so. It's based on what people usually understand, customs, legal precedents, all that. They're kind of like inherent to that type of agreement. The material calls them ex lege, which means by operation of law. They're like the default settings, unless you specifically say otherwise.
So even if it's not on paper, it's part of the deal for certain contracts.
Yeah.
Like with that lease agreement, what would be naturalia there?
Good example. With an apartment lease, even if it doesn't say it, the landlord usually has to keep the building structurally sound, make sure the basic utilities work. Those are often considered naturalia in leases. Two big advantages for you. They protect you from common risks in that type of contract, and it's less hassle because you don't have to negotiate those standard protections every single time.
Good to know. It covers those expected things. Now, in Cecilia, those sound like the add-ons, the custom stuff you decide on.
That's it. These are the extras that you and the other party specifically agree on top of the essentialia and naturalia. They're secondary and can be about all sorts of things, like how you'll resolve disputes, specific warranties, special conditions. They tailor the contract to your situation, basically.
So things like saying, hey, if we disagree, we'll use mediation first, or offering a special guarantee for a service.
Perfect examples. They're the negotiated bits added in to cover what you need beyond the standard stuff. It's what makes your agreement unique.
Okay, so essentially define the type. Naturalia are the implied standard stuff, and incidentalia, that's the custom work.
Now let's dig deeper into these terms, starting with express terms. These are the ones that are clearly said or written, right? Exactly. Express terms are what you and the other party actively agree on, either by talking or writing it down. They lay out the duties, the rights, who does what. It's how you shape the agreement. One thing to remember, unless you mean for it to be different, the contract usually kicks in when you agree, or when someone reasonably believes you agree, not just when you sign something. Unless, of course, signing is legally required for that type of contract. So, these are the terms you can point to and say, this is what we agreed on.
Okay, what about contracts you sign? The material talks about caveat subscriptor, which is like, let the signer beware. That sounds important.
It is. Basically, it means that when you sign a contract, you're generally stuck with all the terms in it, even if you didn't read them all or didn't get them. The law assumes that by signing, you're saying, yep, I agree to all of this. So it's a big responsibility to sign anything. You got to read carefully, not just blindly trust what's put in front of you.
Yikes. So no skimming and signing without potentially getting in trouble.
Pretty much, yeah. Could be bad for you. But there are some exceptions. One is iustus error, which is like a justifiable mistake about what the contract's about, who's involved, that kind of thing. The other is when one side reasonably believed there was agreement based on the document, even if the person signing didn't get all the details.
So if you're tricked about what you're signing, that could be iustus error.
It might be, yeah. The mistake has to be reasonable, and it has to be about something important. Now, the material also talks about these standard form contracts. You see them all the time, right? Like those online click to accept things or standard rental agreements.
Yeah, all over the place. Like as a consumer, you don't really get to negotiate those, do you?
Nope. Standard form contracts, one side sets all the terms and the other side can't really change them. Super common in everyday business.
And what about documents you don't sign? Can those ever be binding?
Sometimes, yeah. If everyone acts like they've accepted the terms, even if they didn't sign, the law might see it as a contract. Plus, express terms, they don't have to be in one document. They can be incorporated by reference, meaning the main contract points to terms in another document, even if you haven't signed that other one. So it's not enough to just look at the main thing. You got to check what else it refers to.
Could be a trap if you miss that other document.
Exactly. Read carefully. Now, there's also ticket cases, like parking tickets. How can those little pieces of paper create obligations for you?
The fine print on the back.
That's it. Ticket cases, you form a contract when you buy a ticket. The terms are usually on the back or displayed somewhere. They can be binding if they were communicated to you in a reasonable way before or when you made the contract. That sign at the parking lot entrance with the terms, that could be important.
So clear communication is key there. And then there are those owner's risk signs.
Right notices. They try to limit liability for potential problems. To be enforceable, they have to be brought to your attention properly. Like that gym sign saying, not liable for injuries unless we're super negligent. If it's hidden away where you'd never see it, it might not hold up.
So just putting it up isn't enough. Got to make sure you see it. Now, the Consumer Protection Act, the CPA, how does that affect all this?
The CPA, it's there to protect consumers. It can override certain contract terms, even if they'd be okay under general contract law. Like even if a contract says no refunds, the CPA gives you the right to return faulty goods and get your money back within a reasonable time. So some terms that look binding might not be if the CPA says otherwise.
So consumer protection can trump the idea,
Yeah.
like you agreed to it, so you're stuck with it.
Exactly, especially when the term is unfair to the consumer. The material also mentions terms that are just straight up prohibited by law. What kind of things are we talking about here?
Things that are illegal, period, no matter what the contract says.
You got it. Terms that are illegal, unfair, discriminatory, immoral, against public policy, or specifically banned by a law, like a rental agreement saying they can kick you out with no notice, that's probably not going to fly under South African law. You can't agree to do something that's already against the law.
That's a good safety net.
Yeah.
And then there's the Conventional Penalties Act.
Yeah.
Sounds like it deals with those penalty clauses.
It does. This act lets courts step in and change penalty clauses. Those are parts of a contract saying you got to pay a certain amount if you break it. The act lets courts lower those penalties if they're way too high compared to the actual harm caused by the breach. Protects you from being unfairly penalized.
So it stops penalties from being totally out of line with the damage you actually caused. All right, last type of express contract mentioned, tacit contracts. We talked about the gardener example, where agreement comes from actions, not words. Ever been in that kind of situation?
Yeah, a few times with services that started informally, but you just kind of know it's a thing because of how you've both been acting. That's it. Tacit contracts, it's all about conduct and circumstances. The actions show there's a deal, even without a fancy document. That homeowner paying, the gardener working, boom, tacit contract. So remember, what you do can create obligations, even if you don't say it out loud.
Okay, express terms. It's the written, the spoken, and even the stuff implied by your actions. Now, what about implied terms? What's different about those?
So implied terms, those are also not explicitly written, but they're still part of the agreement. The difference is how they come about. Tacit contracts, they are a type of express agreement, but it's the conduct that makes the agreement. Implied terms, it's different. They either come from the law, ex lege, or from a kind of unspoken agreement within an already existing contract, ex consensu.
Ex lege first. Does that mean the law just puts those terms in whether you thought about them or not?
Exactly. Ex lege terms, the law says they're there, regardless of what you want. The material splits them into common law and statute.
Common law. Those are the ones from court decisions and legal principles, like things that just make sense based on how things have always been done legally.
Right. They've become part of certain contracts because of precedent and fairness.
Right.
Like the idea that in some contracts, there's this implied duty to be trustworthy and respectful, that's from common law, could be relevant to lots of agreements.
And statute implied terms are like directly from the law itself.
Yep. Written right into laws. They're there for policy reasons, for the bigger picture. Like the Basic Conditions of Employment Act, it sets minimum standards for work contracts. Super important if you're an employee.
Got it. So the law puts those in for certain contracts. Now, ex consensus terms, those sound more like what you meant to agree on, even if you didn't talk about it.
That's it. Ex consensu, also called tacit terms in a more specific sense, those are based on what you both understood from your actions and the situation. It's a wordless understanding, but within an existing contract, not about forming the contract itself, like with tacit contracts.
And this is where the officious bystander test comes in.
Yep. This test, courts use it to see if there's a tacit term. Imagine someone neutral listening to you make the contract, and they ask about something you didn't cover. If you both immediately agree on the answer, that unspoken understanding is probably a tacit term. It's not just stuff you forgot to say, it's also stuff you would agreed on if you thought about that scenario.
It has to be so obvious you both would have said yes.
Totally. There are also rules for these tacit terms. They can't clash with stuff you did clearly agree on, and they have to be clear and specific. No vagueness.
Makes sense? Got to fit in smoothly. Now, there's also trade usage under implied terms. How does that work?
Trade usage is like the norms in a specific industry. If you're in a business where certain things are just done, the law might assume you included those customs in your contract even if you didn't say so. Even if one side doesn't actually know the custom, they could still be bound by it. As long as it's widely known and used in that industry, it makes sense, it's clear, and it doesn't go against any laws or what your contract specifically says. So pay attention to those industry standards. They could have legal weight.
So some industries have these unwritten rules that are just part of the deal for everyone.
Exactly. Moving on to material terms now. These sound pretty important, but how are they different from the others?
Are these the terms that, if you break them, the whole deal's on?
Basically, yeah. Material terms are so important to the contract that if one side breaches them, the other side can usually cancel the whole thing and claim damages. That's way more serious than breaching a non-material term, where you'd usually just have to pay for the damage you cause.
Oh. So if you're buying specific equipment and they don't give you that exact thing, that's a material breach, and you can walk away.
Most likely, yeah. All right, let's talk about conditions. This is a big one with some important nuances. The main idea is a condition makes your obligations depend on something uncertain happening in the future. It's about the if.
Not when something happens, but if it happens at all, and what that means for the contract.
Exactly. First, there's positive and negative conditions. How do those affect your obligations?
Positive condition, something has to happen for the contract to kick in, or for your duty to start. Like you only own the goods when you fully pay for them. Negative condition, something can't happen. If it does, the contract might end, or you're off the hook. Like a tenant agreeing not to sublet.
You got it. Then there's suspensive and resolutive conditions. These are about the timing of the contract.
Suspensive, the contract's on hold until the uncertain event happens, like buying a house, but it's only a done deal if you get the loan. Resolutive, the contract's working, but it automatically ends if something happens, like your job ending if the company gets sold.
Perfect. The material also categorizes conditions based on what triggers them. Potestative, casual, and mixed.
Yeah.
How do these affect your control over the contract?
Potestative, it all depends on one person's choice. Can be a bit iffy if it gives someone too much power. Casual, it's all about chance or external events you can't control, like a contract depending on rainfall. And mixed, it's a bit of both, your choice and something external, like a bonus depending on profits and the board's decision.
Right. Now, what if someone tries to influence whether a condition is met? Like to get out of the deal, maybe even hurting the other party. The material talks about this interference.
Yeah, like if someone intentionally stops a condition from happening, especially if it was meant to benefit you, that doesn't seem right.
It's not. The law calls this fictional fulfillment, or fictional non-fulfillment, depending on what they were trying to do. There's a case, Scott v. Poupard, that set a precedent. If someone wrongfully prevents a condition, the law can act like it did happen, or didn't, if that was their goal. This keeps people from playing games with conditions to get out of their obligations.
So you can't sabotage the deal to escape without consequences. Now, time clauses, they also deal with future events, but those events are definitely going to happen, right?
That's the difference. A time clause says your duty starts or ends on a certain date. Unlike conditions, where it's uncertain if the thing will happen, with a time clause, the event will happen, even if you don't know exactly when. Like conditions, they can be suspensive, gotta wait to the date, or resolutive, duty ends on the date. It's all about the when.
Gotcha. Conditions, it's the if. Time clauses, it's the when. The study guide lists some other common terms, starting with suppositions. Those are like beliefs about the situation right now.
Yep. Beliefs or assumptions about facts when you make the contract. But, importantly, if only one side believes it, it usually doesn't matter legally. Like buying a used textbook thinking it's the latest edition. If only you think that and you're wrong, tough luck, unless the seller lied about it, of course. For a supposition to matter legally, it usually has to be a shared belief, something fundamental to the whole deal.
So, got to be a mutual thing for it to have weight. What about modal clauses, also called modus? Sounds like a condition with a task attached for the person getting something.
That's a good way to put it. A modus says the person receiving something has to do something specific later on. It's not like a condition where the main duty is on hold. The main duty kicks in right away, even though the modus action is for the future. If the receiver doesn't do that future action, it's a breach, and the usual remedies apply. Like donating money, but saying the receiver has to use it for a specific purpose.
So, you get the benefit, but you're legally bound to do that thing later on. Exemption clauses, we touched on those with notices, where one side tries to limit their liability.
Yep, also called disclaimers or limitation of liability clauses. They're usually okay unless they try to exclude responsibility for deliberate bad stuff like fraud or intentionally hurting someone. Courts are strict with these, especially if they're about excluding liability for being super negligent. So they offer you some protection. Remember that Jim disclaimer? Courts would look at that very closely.
Strict means they won't twist the meaning to help the person trying to avoid liability.
Exactly. If the wording's unclear, it'll be interpreted in favor of the person who might get stuck with the liability. Non-variation clauses, those are about stopping informal changes to a contract.
Like saying, any changes have to be written and signed, so no more he said, she said about verbal agreements.
Exactly. That's how they protect the written agreement. Certainty, no arguments about what was said later, like a service agreement saying any changes have to be on paper and signed by both sides. The material highlights how important these are. They stop the original agreement from being accidentally changed by things you say later.
So if it's not written and signed, it's probably not binding, even if you talked about it.
That's the idea. It gives you some certainty. Last one. Governing law clauses. Important when you're dealing with people from different countries.
Right, this is where you say which country's laws apply to the contract in case there's a dispute. Super important for international deals.
You got it. Governing law clauses, they say which legal system controls how you interpret the contract, whether it's valid, what it means, all that. Especially important in international business. Now, you can choose the governing law, but it usually applies to the core parts of the contract. Things like whether the contract is formally valid, whether it's legal, those are often decided by the law that's most connected to the contract, regardless of what you chose. And you can't use this clause to dodge laws that are there to protect people. If there's no governing law clause, the law with the strongest connection to the contract is used. It's all about clarity and avoiding conflicts when dealing with different legal systems.
So it sets the framework, avoids confusion, especially across borders. Wow, we covered a ton today, from the basics of obligations to all these different terms you might see.
We did. Legal obligations, how to classify them, all sorts of terms that shape contracts. It's the foundation of contract law, and it's relevant to everyone.
And like we said at the beginning, this isn't just for lawyers. Knowing this stuff makes you a smarter participant in all these agreements that are part of life, at work, at home, everywhere.
Definitely. Remember, we just scratched the surface. Each of these concepts has layers of complexity. You could spend ages digging deeper.
So as you go about your day, think about the agreements you encounter. Look at them through this lens. How would knowing about, say, resolutive conditions, those deal blockers, or how strict those non-variation clauses are, how would that change how you see things? It's pretty fascinating how these contract law basics actually shape how we interact and what we expect from each other.